It is not like that as if that your complaint is a gospel truth and the court has to accept that truth. There is a delay in lodging the FIR. This is all designed before coming. It is not that. It is not a settled legal position that wherever the girl resides, the court has to transfer at her doorstep. That is not the harass your husband if he is harassing you. 2025 complaint.
Please, why this has happened? If my lords may kindly tell you. Take number below.
And this is all subsequent to the filing of this HMP petition.
5 minutes.
Right.
After receiving the notice, he received a notice. He says that page number 28 may be seen for a moment. Second last paragraph.
Right.
हमारा असील पर તમારા પરિવાર કરે સાલરી માસિક રાશન અંગને અમારા અસીલ પર તમારા પરિવારજનોને તાક કંપનીથી ડરીને તથા પોતાનું દાંપત્ય જીવન સાચવી રાખવા આજ દિન સુધી પોલીસ સ્ટેશન ગયેલ નથી અને બીજી કોઈ જગ્યાએ ફરિયાદ કરેલ નથી. નોટિસના જવાબદાર અમારા અસીલ તમારા પરિવારને જણાવવા માંગે છે કે તેઓ તમારી સાથે દાંપત્ય જીવન ગુજારવા માંગે છે, પરંતુ હવે તેઓ કે તમારા પરિવારજનોના કોઈ પણ પ્રકારના શારીરિક કે માનસિક ત્રાસ કરવા they were continuously in talk with by virtue of their
but this was 13 June 2024 reply.
No other option, she was not accepted.
And then
she was subjected to atrocities by where
yes,
she had to take this.
But this HMP was filed in month of May 2024. After 1 year, we are here, and possibly it was filed before that civil judge Kalol. Then after it was transferred to now family court. Otherwise, it was 1 year back. You have received this notice. And subsequently you have done, and I will say that you are permitted to join through online. No need to go attend the proceeding at the family court here in Kalur. Otherwise, there is a hardly distance 120 kilometers. Whenever you required, only 1 day for cross examination, if it is required.
So she is required to continuously engage with the advocate.
Not required every time. What engagement is required?
But
second, fourth Saturday raja hoy sarkari kacheri ma.
This situation has arrived because of them, then let them come to the DISA court.
But
the girl suffered after going to them.
There is no question of suffering or not suffering. It is not like that as if that your complaint is a gospel truth and the court has to accept that truth. There is a delay in lodging the FIR. This is all designed before coming to this court under section 24. Don't you think that the court is that novice that you don't understand?
I'm not relying upon that FIR. I'm not relying upon that FIR. I have replied to that notice, I'm just saying that the girl is in a job, wherein it would be difficult. She is not permanent government employee.
Maybe, but where she has to attend it, and everyone has their own engagement in the life. It is not that. It is not a settled legal position that wherever the girl resides, the court has to transfer at her doorstep. That is not the law.
It is not
and now in
which she resides there. That is not
and suppose tomorrow she would be transferred somewhere else, then take a hypothetical situation that she would be posted some other district. Then you come with the section 24. Okay, wherever I go, my application should go with me.
But because her parents reside there.
Maybe parents would be. Your parents is not going to.
It would be at some help to her.
But you institute another proceeding at DISA. Harass your husband if he is harassing you.
That she has not done it.
But not done. But she has already filed what she has done by filing an FIR. That is already there. I am not inclined, Mr. What do you want? You want a reason order? I will pass the reason order.
I am not inviting a reason order. But it would be
because as you are working, otherwise my standard order would be that you are entitled to get a maintenance if he doesn't pay you three defaults consecutive in a row. Then you are entitled to file such application with a similar prayer. But as you are earning, that order possibly would not come to your rescue. If you want to have that liberty, I will grant that liberty.
I bow.
Mr. Janati, who are they for the applicant? After asking for some time from under the instruction of his family. He does not, at this stage, he does not raise the present application. Nonetheless, in the council, Mr. Rohit states that at present, applicant is in a fixed term employment she would be entitled to receive a maintenance and transportation allowances under Section 24 of Hindu Marriage Act from the open hearing. So, counsel Mr. Verde states that if an application will be filed by the applicant hearing before the family court comes seeking such maintenance / transportation allowances, family court may be advised or directed to decide such application first before entering into the merit of the matter. Considering the request made appears reasonable, requires acceptance. 2 point, it is open for the applicant to file an appropriate application seeking maintenance / transportation allowance under Section 24 of Hindu Marriage Act. 2 point, if such an application will be filed by the applicant hearing of family court. It is now family court Palol.
No, it is transfer. There is no family court.
Also Gandhinagar.
Gandhi.
Yes, family court Gandhinagar. Then new number must have been given.
Family suit 333 of 2024.
Yes. Family court Gandhinagar.
333 of
Yes,
2020.
yes. Family court of Gandhinagar is hereby requested to decide such application first before entering into the merit of the family suit number 30 of 2024, and after giving an opportunity of hearing to opponent. In a case where applicant opponent hearing is will be directed by the family court to pay maintenance / transportation allowance to the applicant. In such application, and opponent makes default by not paying such amount 3 times consecutive in a row, liberty is reserved in favor of the applicant to approach this court seeking relief which has been paid in the present application with the appraisal observation of money direction from the present application is disposed of as withdrawn, order is to cost. It is made to be this for example,
I will